Good morning, everyone. Good afternoon for those in Europe. It's a great pleasure to moderate a panel concentrated on such a hot topic which will start in Europe and surely spread throughout the world. On December 16, the European Commission will present its long-awaited Digital Markets Act. Even before its release, some consider it a landmark piece of legislation that could deeply change the way the tech sector is regulated in Europe, and why not in the whole world. Basically, the Digital Markets Act is designed to include ex-ante rules for gatekeeper platforms, or the big techs. Rolling out together will be the Digital Services Act, which will include a market investigation tool. These types of regulations tend to have a stronger oversight on illegal and harmful content, and also ensure smaller firms can compete against major platforms operating in Europe. More than considering the size of tech companies, the Act seems to be designed to ensure fair competition in the EU market. Both the Digital Markets Act and the Digital Services Act were first intended to be presented at the beginning of December. I think maybe Mrs. Vestager, the head of competition policy in the EU, had decided to wait for this panel and use the fruitful debate that we will have to receive some valuable input from our speakers before publishing the acts. Very smart, Ms. Vestager. Here, to discuss the main issues of the Digital Markets Act and the Digital Services Act, I am pleased to present our speakers. Our first speaker is Giuseppe Pinelli, an adjunct professor at Luis Guido Carli University at Luis Business School in Rome, teaching the course Legal System in Digital Age and Comparative Corporate Governance. He is currently partner and managing director of Pinelli Schifani law firm and of counsel of the law firm Guarnera Advogados in São Paulo. Then Marco Bota. He is part-time professor at the European University Institute, where he is the coordinator of the Florence Competition Program and entrance for judges. In addition, he is affiliated research fellow at the Max Planck Institute for Innovation and Competition in Munich. He is also adjunct professor at the law faculty of the University of Vienna, where he teaches EU competition and state aid law. And last but not least, Jessica Nemeth. She integrates the in-house antitrust team of a multinational company in Amsterdam, AkzoNobel, and follows a second master degree in international technology law at Vrije Universiteit. I guess I said in the proper way, Jessica. She completed her first LLM in Utrecht University in Law and Economics, where she was granted the Utrecht University International Talent Scholarship. Her master thesis was nominated to the Dutch Competition Authority Awards 2020. But before we get going here, I would like to thank and congratulate IBCI and professors Vinicius Klein and Eduardo Gaban for organizing such a productive international conference on competition and innovation. Professor Giuseppe, the floor is yours.
Thank you, Vicente, and let me thank you again, IBCI, for the invitation, and all the other speakers, distinguished speakers that I have the honor to have with me sharing this panel. Let's start and go directly to the presentation. Let me share the video and the topic, you have said already that the issuing of the Digital Services Act is going to be, is expected to be in the next days. And apart from the hope that our suggestion or the any consideration we will make today is going to be followed by the Commission. What I'm going to cover as an introduction point of this discussion today is the background and the inspiring principles that have been behind the period of creation of this package, whatever is going to be in the package, as we don't know exactly yet. The summarize of the background is here in this slide, and what I'm going to cover is in different parts the issues that have been arising from the previous legal background established by the set of rules that have been approved in the digital world by European Union, and the recommendation that the European Parliament has given to the European Commission in order to create the new rules and propose the new rules, which still have to be then definitely approved to create a modern and efficient background of rules in order to better protect several aspects which are here listed, like the fundamental rights of the users, and to rebuild the consumer trust and to update the aspects of civil and commercial law among all the member states. What is important to highlight is that the expectation of European Union, of the Commission, is to again have an influence on the digital platforms, like it has been with the issue of the GDPR and data protection. So to have an influence that does not stay only inside European Union, but it can create a kind of a pattern to be followed in other countries or outside the European Union, in order to protect more efficiently also the European Union residents from the activity of any platform, wherever it's based. Exactly like it is going on with the issue of the GDPR. The recent declaration of the President of the European Commission revives this issue of the proper use of internet and the need to regulate the potential that this information tool today represents in order to grant the protection of fundamental rights and freedom that are involved by its incorrect and indiscriminate use. The goal is to make the network a democratic, universal, safe, accessible place for everyone, elevating the access to the network to a new human rights universally recognized. These are the premises with which the European Union is preparing to face the actual digital decade. The attention paid by European Union to the digital world is actually dated over time. Although the growing technological development of the increase of today available digital tools require constant updating that makes the regulatory tools as more suitable as possible to the needs of our time. And the current legal frameworks has seized these three main regulations as the most relevant ones. And we have the one we are going to cover mostly in this background description. There's the Directive on Electronic Commerce, and then the regulation on promoting fairness and transparency for users of online intermediation services, and then the regulation establishing the GDPR system. The e-commerce directive adopted in 2000 was aimed at harmonizing minimum standards of liability for online intermediaries across the European Union. The legal framework for digital services defined by this directive has remained unchanged since the adoption of this piece of law. But over the last 20 years, many new ways to communicate have been developed, and those ways are still constantly evolving. Online platforms have brought significant benefits for consumers and innovation, as well as wide-ranging efficiencies in the European Union's internal market. The online platform facilitates cross-border trading within and outside the Union, and they open new business opportunities to a large number of European and, once again, non-European businesses and traders by facilitating their expansion and access to new markets. Although new services, technologies, and business models have brought many opportunities in the daily life of European citizens, they have also created new risks to the citizens and society, exposing them to a new range of illegal goods, activities, and content which are potentially capable of infringing their rights and freedoms. The European single market, therefore, requires a modern legal framework to ensure the safety of users online and to allow innovative digital businesses to grow while respecting the basic principles underpinning the current legal framework of the e-commerce directive. Broadly speaking, under the directive legal framework, digital and online platforms are not legally responsible for hosting illegal contents, but they are required to remove such material once it is flagged. As a result, internet service providers and intermediaries are not liable for illegal or harmful content, goods, or services which may be distributed via their channels if they fulfill certain conditions. More precisely, as we will see in this presentation, intermediaries are not liable if they remove illegal content or disable access to it as fast as possible once they are aware of its illegal nature, or if they play a neutral, merely technical or passive role towards the hosted content. The directive, the e-commerce directive, aims therefore at defining a set of specific rules under which information society service providers, usually referred to as online intermediaries, who host and transmit illegal content provided by a third party, are exempt from liabilities. The directive does not provide with a general liability regime, as I said, for online intermediaries, but it establishes instead specific rules under which those intermediaries are not held liable under European Union law. However, due to the last 20 years of technical development, this EU liability framework is now facing new challenges given by the liability regime regarding, for instance, new actors which appeared on the digital scenes, such as social networks or online marketplaces, above all the others. Furthermore, these challenges have also changed to the nature and the scale of liability, with the development of a range of new harmful online practices, such as the dissemination of terrorist content online, the increasing use of platforms to distribute counterfeit products, and the spreading of false and misleading news and online advertisements. The European Commission has thus committed itself in order to present a new framework aimed at creating and harmonizing the responsibilities of online platforms. This goal has been reached through the commitment to enact a new Digital Services Act this year, which is supposed to set out new rules on how companies such as Google, Facebook, or Twitter will have to police illegal and possibly also harmful content online. This new Digital Services Act package should therefore modernize the current legal framework for digital service by means of two main pillars. First, considering the lack of certainty within the previous directive, the Commission would propose clear rules in order to frame the responsibilities of digital services and to address the risk faced by their users. Second, the Digital Services Act package would propose ex-ante rules covering large online platforms which act as a gatekeeper setting the rules of the game for the user and their competitors. The initiative should ensure that those platforms behave fairly and can be challenged by new entrants and existing competitors so that consumers have the widest choice and the single market remains competitive and open to innovation. In order to better understand the impact of the new Digital Service Act, the impact that the new Digital Service Act will determine within the European Union borders, and once again, not only the European Union border, is therefore useful to highlight the main provision contained in the 2000 e-commerce directive, with main reference to its same scope and the liability regime envisaged by this directive. The legislation has introduced the so-called safe harbor principle, under which online intermediaries who host and transmit content provided by a third party are exempt from liability unless they are aware of the illegality and they are not acting adequately and fast in order to stop it. More precisely, these intermediaries are not subject to general duties of care and are only subject to general duties of care and notice and take down obligation to remove illegal online content. Following this deepening of the European discipline regarding online intermediaries, it must also be underlined that under the EU liability regime, online intermediaries cannot be subject to a general obligation to monitor their users' online content to protect, for instance, users' fundamental rights such as privacy and freedom of expression. A self-regulation instead has been largely encouraged in order to remove and disable accesses to all kinds of illegal information. The e-commerce directive has also been implemented across EU countries. Thus, the national jurisprudence on online liability today still remains very fragmented, while European Court of Justice case law does not provide sufficient guidance in this regard. As a result, several gaps have been identified so far regarding the matter. The first concern that comes to mind with respect of the 2000 e-commerce directive is related to its personal scope. As a matter of principle, the regulation indeed applies to information society services. An information society service may be defined as any service normally provided for remuneration at a distance and by means of electronic equipment for processing and the storage of data upon an individual request. As per the definitions so provided by the directive, it does remain unclear to what extent new types of online services, such as social media companies that have appeared since the adoption of the e-commerce directive itself, fall within the definition of information society services that can benefit from aforementioned liability exemption. Furthermore, while the e-commerce directives provides that the liability exemption is applicable to services normally provided for remuneration, it is instead unclear if it applies to activities sponsored by advertisements or to entirely free models such as Wikipedia. As a result, several studies have been highlighted there are uncertainties surrounding the application of the e-commerce directives to social media companies and collaborative platforms. The European Court of Justice, for example, has been recently asked to rule on the question if the service provided, for instance, by Airbnb or Google must be classified as an information society service. Following the court reasoning, the classification as information society service depends on the degree of control that the platform has over the service provided. The lesser the degree of control, the greater the likelihood of being classified as an information society service. However, the e-commerce harmonization regime is still incomplete, as it still leaves the question of liability for collaborative economy intermediary activities. Following these criticisms, a second issue also comes up. We refer to the safe harbor principles and to the notice and take down obligation as expressed within the legal framework of reference, which seems to be unclear and which needs a proper definition. The e-commerce directive, indeed, provides neither a definition for intermediate service providers, as we said, not a proper notion of safe harbor principle, listing just 3 types of online intermediaries who host and transmit content provided by third party, which are exempt from liability according to this latter standard. If I have to quickly recall them, the e-commerce directive lists 3 kinds of providers. The mere conduit service provider, which are exempt from liability when the service provider is only passively involved in the transmission of data. It can be a utility. Caching providers, they are exempt from liability when they temporarily and automatically store data in order to make transmission more efficient and if several technical conditions for storing the information are met. Or the hosting provider, which are exempt from liability when those companies storing data for their users do not know what they host, that they host illegal activity or information, and act quickly to remove or disable access to the legal information. That means that when these conditions are fulfilled, the EU legislation exempts the online intermediary from a wide range of liabilities, including contractual liability, administrative, tortious, and extra-contractual liability, criminal and civil liability, and so on. Under the safe harbor regimes, online intermediaries are immune from liability unless they are aware of the illegality and are not acting fast and adequately to stop it. In line with this, another question which arises is that regarding the distinction between active and passive role of online intermediaries and those regarding illegal and harmful contents that the directory truly takes into account in order to frame the liability regime provided by it. The problem with this respect is that there is no definition of what constitutes illegal activity and actual knowledge. We are therefore not able to say whether expressions such as illegal activities may also include harmful practices, which are quite common today through the massive use of the net. Harmful content refers to content which often does not strictly fall under the prohibition of a law, but might nevertheless have harmful effect. And we see that a wide range of contents potentially falls into this category, including harassment going from social media and disinformation, the so-called fake news. As long as preventing harmful content, which are not illegal, I repeat, will not fall under the e-commerce directive scope, a new liability regimes, which is able to include both illegal and harmful content, will always be desirable. Furthermore, the concept of passive and active role developed by European Court of Justice and the reasoning of the court itself as regard the requirements of control and awareness also lack clarity. Some experts stress that the differentiation of active and passive role is questionable and complicated, especially for collaborative economy services such as Airbnb, Uber, or even search engines like Google. They propose alternatively using more appropriate concepts, building them on notions such as whether the providers have editorial functions and has a certain degree of control. Furthermore, the e-commerce directives prohibits member states from imposing on online intermediaries a general obligation to monitor information that they transmit or store. However, the prohibition only refers to a general monitoring duty and does not concern monitoring obligation which may be triggered by a specific case. This means that in line with national legislation, national court can impose injunctions on online intermediaries in order to prevent particular infringements. The issue arising at this regard is that since the directive does not specify what the duty of care envisaged by it entails, the boundary between duties of care and general monitoring is not clear, and differentiating general monitoring from specific monitoring obligation, and thus become problematic. As a result, member states have set up different systems, including a notice, a takedown system where the illegal content must be removed, a notice and stay down system according to which the illegal content must be removed and cannot be re-uploaded, and also notice and notice system in which the hosting provider is only supposed to forward the notification of infringement to the alleged infringer. This heterogeneity of models across the European Union leads to a great and overall legal uncertainty. Against this general background, as briefly described above, the European Union has thus been asked to table a proposal for a new Digital Service Act in order to revise the liability regimes so far discussed. The aim pursued by new regulation enacted by European Parliament to the Commission moves from a clarification of the current regime of exemption of liabilities by possibly creating a secondary liability regime specifically provided for online intermediaries. Second, an extension of scope of the EU legislation in order to encompass both illegal and harmful content is also desirable. All of this stands as an essential requirement in order to make European legal framework compliant with the necessities posed by the fast development regarding digital tools and technologies, and in order to clarify whether new digital service providers such as social networks, online advertising services, collaborative economic platform, and online marketplaces could or could not benefit from the safe harbor regime, which is normally provided for internet intermediaries. The Digital Service Act will thus represent the Commission's most ambitious plan to regulate digital services. The package is expected to include a revision of the 2000 e-commerce directive, mainly throughout the introduction of ex-ante rules for gatekeepers platform and through potential provision for platform workers. A wide range of information society services will be impacted by the new rules, such as e-commerce marketplaces, social media platform, online sellers, data services, online search engines providers, and more. More in depth, the Digital Service Act is set as a measure that aims to modernize the current legal framework by means of two main initiatives. On the one side, the Parliament wants to clear rules to implement in order to be implemented in order to define the charges of digital service providers with respect to their user protection, and in order to create a modern cooperation system for the supervision of digital platforms. And on the other hand, rules are proposed to affect also those large online platforms that today act as gatekeepers, guaranteeing fair behaviors and healthy competition in the sector. It's important to remind that the Digital Service Act, after passing all the current phase, then it still to be presented by the Commission to the European Parliament for its final approval. With this series of measures, the Commission intends to replicate what has been done in the field of personal data protection with the GDPR, that is to define a reference standard at the European level, thus shaping the European digital economy on the basis of principles and freedoms of fundamental rules, as provided for by the European Union law. In the meantime, the European Parliament issued 3 resolutions on 20th of October, in which it recognized that the needs for the Digital Services Act, invites the Commission to continue with the presentation of the package, and indicates some essential aspects which have to be included within the new legislation. As we said, in the current legal framework, internet service provider intermediaries are not liable for illegal and/or harmful content, goods, or services which may be distributed via their channels if they fulfill the condition above mentioned. Intermediaries are thus not liable if they remove legal content or disable access to it as fast as possible once they are aware of its illegal nature, or if they play a neutral, merely technical and passive role toward the hosted content, the 3 categories that I mentioned before. We are well aware that this model has, without any doubt, contributed to the enormous growth and success of internet in the past 20 years. Individuals would share their personal photographs, thoughts, and opinion on topics ranging from personal exchanges to political views, while the platform would not monitor for illegal contents and only intervene according to certain community standards, which may ban only some specific kind of content. Thus, today's social media platforms are not liable, as I said, for content provided as a refugee under the shield given by acting as simple host. At the same time, the internet ecosystem it's today based on advertisement revenues. Online companies collect personal data of their users, and in this way, they may understand their preferences, behavior, and choices in order to tailor advertisement. This is why social media platforms play a crucial role on this ecosystem, as people share personal experience and reveal private information about themselves, which can be used to understand their preferences and to better tailor marketing to them. But besides simple videos and personal pictures, some users tend to share and be attracted to content which can sometimes be sensational, extreme, or harmful. For example, violence, hatred, or health fails news, which does require a proper regulation and that sometimes might be even be banned. As a result, the European Parliament's resolution mainly focused on safety of online users, ranging from illegal goods, for example, dangerous products, to illegal content, for instance, violence, hate speech, and so on, by reviewing the liability regime of digital services acting as intermediaries and the gatekeeper power of digital platforms. The European Parliament thus calls on the Commission to address and tackle current shortcomings in the online environment in this new Digital Services Act, due to be presented by the next week, according to the latest news. With the upcoming package, the European Union aims is therefore that to shape the digital economy and at the EU level, as well as setting the standards for the rest of the world, as I already mentioned, and as it has already been done with the data protection rules. Despite the specific scope of the resolution, of the Parliament resolution, we can say that all of them converge on four main points: the need to distinguish between illegal content and harmful content, the need to preserve the main aspect of the e-commerce directive, among which we can mention the limited liability regime, so-called safe harbor principle, the country of origin principle, and the ban on general monitoring. The need to adopt an harmonized notification and action mechanism, the so-called notice and action system mentioned already before, a clarification on the fact that existing sectoral legislation, including the data protection regulation, should be respected and preserved within the issuing of the next Digital Services Act. By means of this resolution, the European Parliament specifically wants the European Commission to focus on the following purposes, which have to be achieved through the future Digital Services Act. First, stricter rules for dealing with illegal content online. All digital service providers operating from third countries will nonetheless be required to comply with the rules on digital services when their services are also aimed at customers or users which are settled within European Union borders. The Parliament then called for a more binding notification and action mechanisms to be established so that users can personally and directly notify intermediaries of potentially illegal content or activities included within the platform. This is supposed to help online intermediaries to react quickly and to be even more transparent regarding the action they have to take, or they have already taken, on potential illegal content, ultimately improving and accelerating the control system originally envisaged by the 2000 e-commerce directive. Users must be also able to appeal through a national dispute resolution body for all disputes concerning the legitimacy or not of the removal of the content that is deemed illegal by the online service provider. Parliament also calls for a clear distinction to be made between illegal content and harmful content, considering that the legal liability regime should only cover illegal content as defined by European and national law. It is thus established a clear boundary line regarding the liability of online intermediaries, which is restricted only to illegal content published online, excluding harmful one, while platforms should not use upload filters or any form of ex-ante content control for illegal or harmful content. It is also said that the final decision on whether the content is legal or not should be taken by an independent judiciary body and not by private undertakings. Another principle is the safer internet for consumers. In addition, specific ex-ante rules aimed at preventing, rather than just remedying, market failures caused by large platforms must also be set out with the new Digital Services Act in order to open the market to new players such as startups. With the aim of granting consumer and user safety, the principle of what is illegal offline is also illegal online should thus become the future Digital Services Act's guiding principle. platform and online intermediation service will be asked to detect and take down false claims and also to struggle against unfair traders. An example which is given by those selling false medical equipment and dangerous product online, as we've seen happening during the current COVID-19 outbreak. Along with this rule, the European Parliament also called for a new Know Your Business Customer principle that has to be introduced, requiring platform to monitor and stop fraudulent companies using their services to sell their illegal or unsafe products and content. And one of the latest principles, make users less dependent on algorithms. The Parliament also wants to give users more control of the content they are exposed online, that they're exposed to online, by allowing them to disable automatic content selection and make them less dependent on algorithms. Target advertising must be more strictly regulated in favor of less invasive form of advertising that requires smaller amount of data and do not depend on previous user interaction with content, ultimately also enabling the possibility of a ban in case of non-compliance with this rule. Parliament finally calls on the Commission to make a distinction between commercial ads and political propaganda in the forms of online advertisement, which is aimed at conveying ideological messages through online platform. The upcoming Digital Service Act should also provide for the right to use digital services anonymously, whether that is possible and whether desirable for the customers. Lastly, to assure compliance with the new rules, the Commission should also assess options for setting up a European entity to monitor and impose fines to those who breach the law. And last principle that is pushed forward by the resolution of the European Parliament in its third non-legislative resolution is focused on fundamental rights online. And in this resolution presented by the Committee on Civil Liberties and focused on fundamental rights issues, digital service providers are called upon to withdraw the content from the data network in a diligent, proportionate, and non-discriminatory way in order to safeguard the freedom of expression and information, as well as the privacy and protection of personal data. Emblematic on this regard is the judgment of the European Court of Justice number 623 of 2017, with which it established that the need of national security and the fight against crime do not legitimize indiscriminate retention of data by the providers of electronic communication services. Therefore, the national law, according to this decision and this example of UK, Belgium, and France, which require telecommunication companies to transmit personal data to intelligence agencies in the name of national security, as a result, is resulted as not compliant with the 2000 directive. However, the court also clarified that in situation where the member state is facing serious threats to national security, which can be demonstrated as an existing or at least foreseeable, this principle of limitation may give space to the necessity of disregard the confidentiality and data protection. As we saw, even with regard to this exception, proportionality in any case always remain the key principle for addressing any action from the member states and the operator. This is a principle of major importance coming from the European Court of Justice ruling concerning the relationship between freedom and security, and aim at avoiding that expansion of notion of national security may actually end up by circumventing through the use of net the effectiveness of protection of other fundamental rights, such as I said, freedom of privacy of data. In conclusion, this piece of law that, or this package of rules that's going to be issued and we are all looking forward to look at is definitely going to have a huge impact on all the aspects of the digital economy and is going to shape for sure the activity of the bigger players, what I mentioned as gatekeepers, but also the new upcoming players, not only European Union, but also in all the world, for those players who aim to be in the market of European Union residents. And I hope I've been in my time, Vicente, with my speech, and I give you back the floor, and I thank you.
Thank you, Giuseppe, for your overview about the new acts, but very detailed overview. And now the floor is yours, Professor Marco, or should I say, adesso tocca a te.
So, thank you, Vincent. I'm very happy to be here with you today to discuss the proposal of the Digital Market Act that the Commission is expected to issue next week. When we talked for the first time about this panel in November, we were all thinking that this panel would have taken place after the Commission released its proposal, but that has not been the case, as already mentioned by Vicente before. So what I would like to do with you is somehow to do a sort of speculation of the main question behind the DMA proposal, so to discuss what is the rationale behind the proposal, when the legislation would be applicable, what conducts would regulate, how to regulate them, and last but not least, who should enforce this new set of rules. And finally, I will try to compare this new proposal by the Commission with the new proposal in the United Kingdom that is also willing to regulate the behavior of tech giants, and a proposal was put forward at the end of November this year. So as you all know, when we talk about digital platform, we talk about very different companies that have different business models. They operate in different sectors. But as argued recently by Martin Paetz in a working paper published by the University of Mannheim, all the digital platform basically include three different players. So the platform as such, which is the sort of intermediary, act as intermediary between the different stakeholders accessing the platform, the so-called attention seekers that can be advertisers, but also retailers that try to sell their goods and services via a marketplace, for instance, and they look for the attention of their targets, where their targets are us, the final consumers. So this is somehow a model that tries to provide a sort of holistic idea of a digital platform, and this is in line with the idea of the Commission proposal that tries to provide a sort of general regulation applicable to all the digital gatekeepers independently by the specific business model and business sector where they operate. All these digital platforms also share a number of common features in terms of sources of market power, like switching cost for users, direct and indirect network externalities, the ability to collect a large amount of data concerning their users. But I will not spend a lot of time on these points, since I know that Jessica will discuss these issues in more details in her presentation. So as mentioned by Giuseppe before, the Commission published in June this year two public consultations, one concerning the digital service sector that included two main topics, so an update of the 2000 e-commerce directive discussed before by Giuseppe, and the introduction of ex-ante asymmetric regulation for digital gatekeepers. Then a separate public consultation concerned the so-called new competition tool, NCT, which is inspired by the market investigation that the Competition Market Authority, the CMA, can conduct in the United Kingdom. So basically, the CMA can conduct a sort of very similar to what the Commission does in terms like a sort of sector inquiry whenever it considers that a certain industry has some kind of structural competitive problems, but unlike of the Commission, at the end of the investigation, if it finds, of course, some competitive problems, it can adopt remedies, behavioral and structural remedies, but it cannot impose a fine. So basically, it can regulate a market without finding any competition law violation. For instance, the market is somehow oligopolistic, so because of the structure, it's likely that the parties will collude, but there is no exchange of information of the parties, there is no evidence of direct collusion. So that's enough for a market investigation to trigger some remedies, while this will not be possible for the European Commission under the current EU competition rules. So next week, the Commission is will publish the new package. We still don't know, let's say, how the package will look like, but in my opinion, the package will include two separate legislations. So the Digital Service Act, the DSA, will basically focus on the update, the amendments to the e-commerce directive. So it might be likely to be a directive as such, while the DMA will include the rules about ex-ante regulation for digital gatekeepers and a very limited, from what we have read from the newspapers, a very limited NCT. So the Commission has somehow given up on the initial idea to have full market investigation powers like the UK Competition Authority. The Commission will have some residual NCT powers only in the field of digital markets. But in my view, if these powers are enforced by the Commission, this will be a regulation. So clearly will be a different type of legislation in comparison to the DSA. Both legislation next year will have to be discussed and approved by the Parliament and by the Council. At the moment, the reason of the delay of the publication of the package seems related to the legal base, especially of the DMA proposal. So DG Competition would like to propose the DMA under Article 114 of the treaty, which is the internal market legal basis that allows the Commission to propose directives and regulation aiming at harmonizing national legislation to establish the EU internal market, and jointly with Article 103 of the treaty that allows the Commission to propose legislation for the application of Article 101 and 102. So if we look at the DMA, clearly no one of these two, at least in my opinion and the opinion of several commentators, no one of these two legal bases fit. First of all, the DMA does not harmonize national legislation for the purpose of establishing the internal market. And secondly, ex-ante regulation, it's not competition law. So NCT is clearly not part of Article 101 and 102. So a number of commentators argue that the correct legal basis would be Article 352 of the treaty that allows the European Union to adopt legislation even when it does not have a specific legal basis in the treaty. But let's say what is the difference with the previous legal basis is that here unanimity is required in the Council. So all the member states have to agree, and clearly the Commission would prefer to base the legislation on Article 114 and 103, where the qualified majority, so two-thirds majority in the Council, is needed rather than unanimity in the Council. The legal basis will be very important because the DMA will be certainly a contested legislation, even if it's approved, probably will be challenged at the Court of Justice, which will have eventually to quash the validity of the legislation if the legislation is based on a wrong legal basis. So this is the reason why the legal service of the Commission is putting so much emphasis at the moment on the legal basis of the Act. And I think that this is the main reason of the delay of the publication of the proposal. So the first question that I would like to discuss with you today is why we need a DMA, why we need ex-ante regulation for digital gatekeepers. So first of all, in the last 2-3 years, we had a number of antitrust investigations and decisions, not only by the European Commission, but also by other competition authorities, that have sanctioned the certain type of behaviors by digital platforms. So I'm thinking about the Google Shopping case in 2017 by the European Commission, which is not a unique case. It's rather similar to the Amazon commitment decision by the Bundeskartellamt in 2019. So the idea is that digital platforms, very often, they try to give preference to their own product. So that is the concept of self-preferencing. Another common type of conduct that is subject to antitrust scrutiny during the last years is the idea of exclusionary binding time. Think about the Google Android decision, again from the Commission in 2018, where among the violation of Article 102 contested by the Commission was the fact that Google pre-installed in all the Android system the Chrome as web browsers and Google search. So this idea of bundling is not new in competition law. It's very similar to the Microsoft case decided in Europe in 2004, concerning the bundling between Microsoft operating system and Windows Missile Player. And apparently it's a very common practice nowadays by digital platforms. And the last case that is currently investigated by the Commission, and the Commission opened an investigation a few weeks ago, is the preferential access to consumer data. The last Amazon case, where basically the Commission is arguing that Amazon has a preferential access to the data of the users, of the retailers that use Amazon as a marketplace, in order again to self-promote its own sales. So these three categories of conduct, as you can understand, are the categories of conduct that are at the moment discussed to be sanctioned under the DMA, but are also potentially type of abuses under Article 102 of the treaty. So there is the overlap, it's between the DMA and Article 102. It's not with merger control. And also this type of conduct are all exclusionary practice. So the digital gatekeeper try to exclude competitors that use the platform. Conducts like exploitative abuses that were, for instance, at the core of the Facebook decision by the Bundeskartellamt are not included within the scope of the DMA. So in spite of the repeated investigation and decision by the antitrust authorities in Europe, there is a sort of general perception that antitrust enforcement does not have a sufficient deterrent effect vis-à-vis the behavior of digital platforms. So think about, for instance, the 3 Google decisions where the Commission imposed overall a fine of over 6 billion euros. This is still a very small fraction of Google worldwide turnover. In the recent case started by the Department of Justice in the United States against Google in the Google search case, the Department of Justice contested that every year Google pays between 8 to 12 billion euros to Apple in order to pre-install a Google search in Safari browser. So you understand, what we are talking about, that the antitrust fines as such are really insufficient in order to have a deterrent effect in this area. And at the same time, the antitrust investigations are also very long. They are quite ineffective. Think about the Intel saga that started approximately in 2000. It was sanctioned by the Commission in 2009. The General Court ruling was in 2015, 2018, the ruling of the Court of Justice. Next year, we expect the new ruling of the General Court, and then afterwards, we'll probably have another ruling of the Court of Justice. So in order to conclude the legal saga, we will need a quarter of a century. Clearly, this time frame does not fit with the rapid evolution of digital market. So another reason, let's say another category of reasons that I would say define as political reasons to justify the approval of the DMA are, on the one hand, the fact that a number of member states, Germany first of all, are currently considering at the national level the idea to regulate digital gatekeepers. Germany is considering the possibility to adopt to an amendment to the competition law that would give to the Bundeskartellamt the powers of conduct marketing investigation, like the British Competition Authority. So this somehow might lead to a fragmentation of the unity of the internal market. So there is a need by the Commission to preempt, let's say, national legislation via a proposal at the EU level. And then another political reason is the perception that the European Union is lagging behind the United States and China in terms of technological and digital innovation. So all the big techs are US companies. When you read, for instance, a recommendation by the European Parliament to justify the adoption of the DMA, you see the idea that US tech companies should be subject to stronger, stricter regulation in order to open the space to the small European digital platforms, let's say. And this is also behind the idea of the DMA, which is based on asymmetric regulation. So only the big ones are subject to the regulation, while the small platforms are not subject to these additional regulatory burdens. Let's now move to another question. When we should apply the DMA? So we know that the DMA will be applicable only to platforms considered digital gatekeepers. We still don't know exactly the definition of digital gatekeepers, but a couple of weeks ago, the Director General of DG Competition mentioned in a press conference that digital gatekeepers are unavoidable trading partners. So the question is there any difference between an unavoidable trading partners and the concept of dominant position under Article 102? In my perception, there should be. So when I think about digital gatekeeper, I think about a platform that controls the market, that is almost monopolist on the market. But if we look at the case law of the European Court of Justice, for instance, British Airways or also Hoffmann La Roche, we see that very often the Court of Justice mentioned that a dominant company is per se an unavoidable trading partner for its customer. So there is no clear differentiation in the case law of the Court of Justice between dominant position and unavoidable trading partner. And if the Commission decides to go for a very broad understanding of what is a digital gatekeeper in the DMA proposal, the risk is that when the legislation will be interpreted by the Court of Justice, then the court might refer, let's say, to its previous case law, and we might get to a situation where unavoidable trading partner might be equal to dominant position. Another question is what conduct to regulate. So we know from some press leaks that the DMA will include a certain list of conducts, behaviors that the digital gatekeepers are prohibited to perform. So certainly we will have a black conduct, which will be per se prohibited. Last week, Commissioner Vestager at the OECD Global Competition Forum mentioned that self-preferencing very likely will be a black conduct. There will be also white conducts per se allowed, and more probably gray conducts, which will be subject to a sort of case-by-case analysis for a subject under what remains of the NCT in the DMA proposal. So this idea to have different categories of conduct is very similar to the block exemption regulations, where an agreement is considered exempted under Article 101, paragraph 3, if the market share of the party fulfills certain thresholds, and if the agreement does not include any black clause, any hardcore restriction. So this type of approach to regulate digital gatekeepers is positive in the sense that it provides legal certainty to digital gatekeepers. So the companies will know what they can and what they cannot do. But it's also negative because it shows a very old approach of the Commission in enforcing EU competition rules. It's very much against to the idea of the more effect-based analysis in competition law that the Commission is somehow repeating in the last 20 years, and that the Court of Justice has finally endorsed more recently in the Intel judgment. So the idea of the effect-based approach is that no conduct can be per se prohibited. The competition authority should always assess on a case-by-case the effect, the anti-competitive effects of the conduct on the consumer welfare. Clearly, a list of black clauses does not follow a case-by-case analysis, but it follows a more old, let's say, legalistic approach. Then the next question is how to regulate digital gatekeepers. And here the question is related to the possible remedies that the Commission would be able to apply under the NCT. So basically in all the cases which are not per se prohibited in terms of conduct, where the Commission might perform a sort of market investigation and might find out at the end of the investigation that there are some structural competitive problems that in the digital market that require some kind of remedies. So in the United Kingdom, as already mentioned, it's not possible for the CMA to impose fines after the end of a market investigation. We don't know if the Commission will be able to impose fines under the DMA proposal for a breach of black conducts by the digital gatekeeper. Structural remedies are also probably unsuitable at the end of the NCT investigation. Why? Because structural remedies in terms of unbundling of digital gatekeepers would affect negatively the network effects of the platform and would harm, let's say, the welfare of the consumer. So we all use a social media or a marketplace because we appreciate as consumers that the social media is a very large number of users. So we don't want, let's say, the digital gatekeepers to be cut in pieces. What about behavioral remedies? So the CMA concludes when it decides to impose remedies at the end of the market investigation, usually adopts behavioral remedies. One behavioral remedies that could be considered in this case is a data sharing obligation. So the digital gatekeeper will be required to share its data set with competitors, with third parties. But then the question is, from a technical point of view, are these data that are shared useful for the third parties to fill the gap between the digital gatekeeper and the competitors? And second, is this practice compatible with the GDPR, with the General Data Protection Regulation, at least when the data sharing obligation concerns personal data? Clearly, the GDPR requires express consent by the data users. So the data sharing obligation will be able to be imposed only if the data would be anonymized. Then there are other behavioral remedies like disclosure or transparency obligations, which are, let's say, would also be possible. But overall, I would say that the NCT remedies would be very similar to the remedies that the Commission can already impose at the end of a competition law investigation. So I would not see really any difference. And we will have the same problem of effectiveness of the antitrust remedies that we already see when the Commission decides to enforce competition rules in the digital sector. The last question that I would like to discuss with you is who should enforce the DMA rules? This is the main open question because we know very little, let's say, about the intention of the Commission to this regard. We can suppose that the Commission would not like to transfer the power to enforce the DMA rules to the national competition authorities. The logic, the rationale of the DMA proposal, as I mentioned before, is actually to prevent national legislative initiatives. So this decentralization would be, let's say, against this idea. I also think that it's unlikely that the Commission in the DMA proposal will propose to establish a new digital tech regulator at the EU level. Why it's unlikely? Because under the case law of the Court of Justice in Meroni, the EU institutions can delegate their powers to other regulatory agencies only when the powers are executive powers, very clearly defined, but not discretionary powers. So that's the reason why in Europe we have a number of regulators at the EU level in very specific sectors, in regulating, I don't know, what type of drugs to release in the market, food safety, and so on. But we don't have, but it's the Commission to enforce the competition rules that require sort of enforcement of discretionary powers. So I think that it's very unlikely that the delegation to a digital tech regulator at the EU level of the enforcement of the DMA would comply with the case law of the Court of Justice. So the last option is that the Commission as such enforce the new DMA rules. It's the more likely option. But then again, we come to the same issue of the overlap between Article 102 and the DMA. So then the question is, when will the Commission decide to enforce Article 102, or when will prosecute the case under the NCT, let's say, within the scope of the DMA? This is, let's say, an open question. As I already mentioned before, at the end of November, the United Kingdom issued a proposal to regulate also digital platforms. So the proposal is rather different in comparison to the DMA proposal. It's still not final, but it's interesting to compare them. So first of all, the proposal comes as a follow-up of the CMA market investigation on online advertisement. So we're talking about only Google and Facebook. We are not talking about Amazon. The CMA published the results of this market study in July 2020, and it noticed that in the online advertising markets, generally, the CMA found high prices for digital advertisement and lack of consumer controls over, let's say, the content of digital advertisement. So the next step is to adopt some kind of remedies after this market investigation. Remedies will be mostly behavioral remedies, which will be negotiated with the parties. So the parties will have to accept a sort of code of conduct. Also, the CMA has already established a digital market unit within the CMA. So as you can notice, the UK proposal is much more narrow than the DMA. It only concerns digital advertisement. It's the conclusion of a traditional market investigation by the CMA. And it's likely that in the coming years, the CMA will continue other market investigation in relation to digital platform, and will then adopt on a case-by-case certain behavioral remedies. So, as you probably know, the United Kingdom has already exited the European Union beginning of January this year, and during the year 2020, United Kingdom remained part of the EU internal market via this transitional agreement. The agreement will expire at the end of December, and so far, from what I have just read on the newspaper, there is no agreement between the European Union and the United Kingdom to have a forward-looking agreement of cooperation. So at the moment, a likely option is that we will have a hard Brexit from 1st of January. So little by little restriction to the free movement of, let's say, capitals, goods and services and workers will be re-established between continental Europe and the United Kingdom. The relationship between the two, let's say, blocks will be regulated by WTO law in the lack of bilateral agreement. And clearly in this political context, we see the emergence in Europe of two, let's say, models of regulation of digital platforms. So the DMA on one hand, which is very broad, it covers all the digital gatekeepers, it's a binding legislation, and it's asymmetric regulation, based on asymmetric regulation, while we have the UK approach, which follows its traditional market investigation approach, so case-by-case approach and behavioral remedies. So we will have to see how this differentiation will also play in the economic relationship between the European Union and the United Kingdom in the future. So I come to my conclusion. So I basically started with the argument that there is a growing consensus in Europe that antitrust enforcement is ineffective vis-à-vis digital markets. So there is a consensus that digital gatekeepers should be subject to ex-ante regulation. A few weeks ago, we organized in Florence another conference about the DMA. One of the speakers, Jorge Padilla, who is well known as not being in favor for antitrust enforcement vis-à-vis digital platforms, argued that basically the regulation of digital platforms is something to be accepted, let's say, in Europe. The train has departed, we cannot stop it. So we will have a DMA next year or the year after. So it's clear that Europe wants to regulate digital gatekeepers. Then there are a number of open questions. Probably some of these questions will be clarified next week when the Commission will publish its proposal. Other two issues that I think remain open are the fact that the regulation concerning platform to business just entered into force in July 2020. That is also a regulation concerning the behavior of digital platform. It has horizontal applicability, it does not apply only to digital gatekeepers. We still don't know what is the impact of this regulation in practice. We also still don't know what is going to be the ruling of the General Court and then the Court of Justice in the 3 Google decisions. So we don't know if the Court of Justice will consider self-preferencing in Google search as an abuse of dominance. So my feeling is that perhaps the Commission is trying to use the political momentum to legislate in this area, but it might rush to regulate when there are still a lot of unclear aspects to be clarified. And at the same time, we see that also United Kingdom is developing a sort of alternative regulatory model vis-à-vis digital platform, alternative to the EU model, and we will have to see how these two models will coexist in the future. So my final recommendation is stay tuned. So we will see next week, probably on 15th of December, the Commission will publish finally this proposal. I truly hope the Commission will not further postpone the publication of the proposal. We will read it, and I'm sure we will have further occasion of discussion and occasion to comment the DMA. So I thank you for your attention, and now I would like to give the floor to Jessica, who will further discuss the DMA proposal.
Thank you, Marco. 1 second, I'm going to share my presentation. So thank you, everybody. Good afternoon in Europe and good morning in Brazil. It's a pleasure to be here today with both Marco, Vicente, and with Giuseppe to discuss the DMA proposal. Sadly, we don't have the text yet, so what we will be discussing here today are only thoughts. Maybe we receive on the 16th something completely different. And my presentation will mostly focus on the question, what is a gatekeeper? Because most of the consequences or the obligations for the tech companies will be applicable after you define who is this new legal figure. So these considerations might be relevant in practice. The roadmap for my representation is quite short. First, I will briefly recap what Marco and Giuseppe mentioned about the DMA pillars. Then I will briefly discuss why some businesses are more successful than others in the digital sector. Third, what I understand that will be some of the criteria of the gatekeepers. And fourth, make small parallels of the DMA and the Brazilian antitrust. So the DMA basically has two pillars. The first one covers mostly the e-commerce directive and creates obligations to tech companies to protect customers from illegal goods and content, and also other types of fundamental rights. And the second pillar that the European Commission wants to focus is the creation of this asymmetric regulation, like mentioned by Marco. So this ex ante rules to this new legal figure called gatekeepers. But before we go to what we expect to be a gatekeeper, I think it's important go a step back and understand how these big tech companies are proven so valuable and so profitable, and how do they get more and more consumers. Like Marco mentioned, they have a lot of sites. And for this exercise, I would like to use the aggregation theory created by Ben Thompson. Ben Thompson is a tech writer, for those who doesn't know. He has a very interesting blog called Strategy. I really recommend you visit his website. The articles are very clarifying to understand how the models work. I'm not affiliated to him, so I'm making any money. It's just think it's a good framework of analysis. So the digital companies that are very successful, they provide the consumer with better discovery, and they do that by analyzing our digital footprint in the internet, and they sort results out. So what happened in the past before the internet is that you had a small range of choices. So if you wanted to buy, for example, black shoes, you would have 5 stores around your neighborhood that you could go. And with the internet, you can see more than 1,000 stores anywhere in China or across the country or the Atlantic that you can purchase. But this information is really difficult to process. So as a consumer, in the internet, you go to an aggregator because the day has 24 hours, and you need somebody to help you to sort things out. And the aggregator provides this type of service to the consumer. This is what Ben Thompson called the super aggregator method. And for him, there are 3 characteristics for the aggregator. So the aggregator has he has the direct relationship with the consumer. The second one would be that it has 0 marginal cost to include new consumers on board. So comparing to other markets where you have distribution costs and production costs, the aggregator doesn't have any of them. And the third one which is the network effects. So that basically the aggregator provides value by sorting things out. And also Ben makes a distinction. So there are 3 levels of aggregators. I think it's important to illustrate how they do that. So the first level are the aggregators that have supply acquisition costs. So they still need to pay for the product. This is the case of Netflix or Spotify. They still need to pay a lot of money to acquire content to let the users watch the films and also listen to the music. The second level of aggregators is the one that has transactional supply costs. So in order to increase their supply in the platform, they need to transact with these other companies. And this would be the case of Uber or Airbnb, which they still need to make some assessment inside the firm to invite more drivers, to invite more apartments. They need to comply with the regulation. So they still have costs on that side. And the third level would be the aggregators with 0 supply cost, which mostly refers to companies like Twitter and Snapchat, because they create content when the users interact, so they don't need to pay. And the fourth level would be the super aggregators, which is the category that I understand mostly aligns mostly with the idea of gatekeepers. So the super aggregators, they have at least 3 sites in their platform, and they have zero marginal cost to all of them. And these three sides would be users, advertisers, and suppliers. So if you see the business model of Google, it has these three sides and it commoditizes the companies. So instead of being another platform, you're just a commodity when you're listed, when you see a list from Google. So thinking about the internet, they are very different from the theory from Untitled. Things developed very fast these past years. So let's go to the gatekeepers and what we can expect and what we have seen from the speeches and the press conference and newspapers. For me, it's still a bit unclear whether the gatekeeper category will be applicable only to the service. So if the service is considered a gatekeeper, this will expand the entire undertaking. So in case the undertaking is a very big tech company and the service is a gatekeeper, if it starts a new project, we'll be able to use, if self-referencing is the blacklist, if we will be able to use self-referencing in this new service. This is still yet unanswered. So this is the first idea and concern I would have with this idea. What would be a gatekeeper in terms of criteria? What can we expect? This is a copycat of a question of the questionnaire that the European Commission issued in June during its public consultation. It has several characteristics that they ask the public. Is this relevant or not? Please rate between 1 and 5. I'm going to discuss only 4 that I consider that will be very difficult for companies to self-assess or to experience in practice. And like Marco mentioned, digital markets, everything goes so fast. So to make this in practice, how the authorities are going to manage to monitor this amount of companies that are emerging. And for this exercise, the first category, so large user base, how we are going to calculate it. I first got from the leaked information that the threshold would be 2 billion people. And yesterday, while I was researching, I read at the Financial Times that the threshold will most likely 45 million users, or 10% of the population of the economic bloc. So if you take Facebook as an example, the total number of users is between 2.4 and 2.7, but you see that in terms of distribution of the user base, most of this user base, it's not in Europe, it's outside Europe. So my question is how we're going to calculate that, because it needs to in theory, and from all the public press speeches we got, the effects should be focused on the single market. So the user base is outside. How are we gonna make this correlation? This is a question yet to be answered. The second point is that the gatekeeper or the aggregator needs to have strong network effects. And this sometimes, it's in theory, is very beautiful. We all know that, if, for example, with telephone, there are strong network effects. You don't have much incentive to buy a phone if there's nobody in the other side using it. And I would like to bring here the case of Zoom. You're probably tired of listening to Zoom. Is the different case of network effects in the digital markets, but Zoom competed with incumbents that did have deep pockets, and they did have a very large user base. So in theory, the consumers would not have this incentive to migrate to Zoom. But what happened is that Zoom didn't even disrupt the market. They just provided a better product. And this is the platform that we are using today. So, and how we are going to assess and prove this in practice? Are we going to establish a time frame? How is this gonna work? How the companies are gonna self-assess? The third point is that the value of data. So one of the criteria to define the gatekeeper is that the gatekeeper has access to valuable data. But what is valuable data in the digital markets depends a lot on the product and depends also a lot on how it's processed. So the amount of data you have is great, but sometimes, and this happens with several big tech companies, you can produce the same output using different data sets. And the value of the big tech or the aggregator is not the amount of data that it can process, but the curation. So how good it can predict. And this is mostly very attached to the algorithm it uses to process the information. So how are we going to establish that a gatekeeper has access to data that's very valuable if we spread a lot of digital footprint in the internet, and also data is different for different purposes. So it might be the case for a cosmetics platform, or I don't know, a cosmetic aggregator, that age is very relevant, but for other one, age is not that relevant. And how we are going to monitor this and do this in a very fast time frame, it's yet to be seen. About this topic, I've read recently in this article by Gatter and Tucker, some recent studies that show that after the GDPR, the big incumbents were able to reduce the amount of data they process, and they still keep the same quality of the curation. So instead of 10,000 lines of data in an Excel, after the GDPR, because of the personal information obligations, they reduced to half of it, and the result was still good. So you see the diminishing returns to the power of data. And considering this is one of the criteria of the gatekeeper, how you're going to assess this in practice, a question yet to be seen. And the fourth point I would like to discuss here is that lock-in. So gatekeepers are in markets that the consumers are locked in, but in the digital world, lock-in changes really fast. So what many commentators argue, and I think this is also one of the arguments used in the European Commission in the Google Android case, is that once you are in an operative system, you're locked in because you have so much switching costs to move your data, move your conversations from your apps, your pictures to another type of phone. So move from Android phone to iPhone, it's very costly. And yesterday I said, okay, let me try to do this exercise, how hard it's going to be for me to move my data from one operative system to the other. And you see that in YouTube, which is a platform from Google, Apple published a video on how you move all your data from one phone to the other. You don't need to be tech savvy to do this. It's a video of 2 and 30 seconds that really shows you how to do it. And if this is a criteria of a gatekeeper and it changes over time, then I might expect a lot of difficulty of the authority of showing that, yes, the consumer is locked in during this period. Now you cannot use self-referencing. But if tomorrow the undertaking, who is the gatekeeper, allows it to switch to the other platform, then it's not a gatekeeper anymore, and then it can use self-referencing. It's a bit contradicting, and it's a bit difficult to do it in practice. So after these considerations, I would like to move a bit to Brazilian antitrust. So what did I do? I looked into the data and I saw that CADE current enforcement, so the decisions, are still mostly focused in cartel decisions. So Article 101 decisions, about 70% was cartel decisions in 2020, and only 13% focused on an unilateral conduct that's equal to abuse of dominance in Europe, so Article 102. But if you think about cases that are being opened, this distribution is more equal. So 40% of the cases in 2019 were about abuse of dominance. And you see that CADE in terms of digital markets is in a second mover advantage position. you see a lot of activity in terms of studying the digital market. So in August, for example, you see that CADE issued a study comparing and all the other studies from the authorities, that also including the study and the the Director General paper on competition policy for shaping the digital era. And the message was that the CADE is closely looking into it, but yet is still waiting. So I expect that in the future, after that the DMA takes place, that we could see more activity in that term, in that sense. And I would like to end my presentation with this phrase from Bill. I think it's a very good phrase because we need to think that law is not able to fix all the issues in the digital world. Law is a quite slow instrument, and perhaps being more dynamic in terms of technology would be an answer to address these issues, or maybe a different approach. Thank you very much for the opportunity, and I look forward to the discussion.
I would like to thank so much Jessica, Marco, and Giuseppe for those didactic and very informative presentations. I'm sure then helped us to understand what's going on in Europe and how it somehow can affect Brazil and why not the whole world. Well, consider that we are almost in the end of our panel, but before close it, I would like to ask to each one of you a question, but I would ask you to be very straight to the point, no more than 3 minutes for each one, and you can take this opportunity also for your final remarks, okay? I will start asking to Giuseppe. Giuseppe, what could you tell us about the approach of EU and US to safe harbor principle on liability of intermediaries?
Thank you, Vicente. Well, as always, the approach of European Union is more protective to user than US. US is more market-oriented. So regarding the safe harbor principle, one main point is the burden of proof in order to proceed with the notice and take down liability. So in order to have the possibility for the provider, intermediary, to enjoy the safe harbor principle. And in Europe, it's the intermediary who has to prove that he has not had any knowledge of the illegal content put by a third party inside the platform, while in US is the plaintiff, so the person who is claiming to be damaged by the content, who has to prove that the platform has a knowledge of the illegal content. So it's the burden of proof is definitely higher in US in order to protect or to have the intermediary to remove the illegal content. And a proof of these in Europe is the case of the famous case Google against Louis Vuitton, where the brand Louis Vuitton has been awarded with a decision from the European Court that against Google, where Google claimed that it was not aware of the publishing of some online store of counterfeit products, while the court ruled that the kind of power that Google has, the kind of control that Google has on the content is then creating a responsibility, a liability on Google on not removing this illegal activity from its online online shopping section of its search engine. So basically, that's the answer. The US are always allowing more. EU is always focusing more on protecting the rights of their user.
Thank you, Giuseppe. Marco, could you share with us your opinion concerning the new competition tool? As far as I know, it is not clear whether and to what extent the new competition tool will be included in the DMA?
Thank you, Vincent. Yeah, indeed, this is the reason why I did not discuss in detail the NCT, since we still don't know exactly the scope of the NCT. But even if a reduced version of the NCT limited to online platform basically was included in the DMA proposal, I think this tool will not solve the issues that I have mentioned in my presentation. So my presentation, I stressed that the reason of behind the adoption of the DMA are the fact that the antitrust enforcement is ineffective in terms of remedies to deter violation of convention rule by online platforms, and simply it takes too much time, it's too long, the antitrust proceedings are too long. So in terms of remedies, the remedies adopted under the NCT, United Kingdom by the CMA, are the same like in competition law. There is no any type of difference, so the problems are the same. Also in terms of timing, the CMA market investigation also lasts for a long period of time. Their final decision is hundreds of pages. They collect a lot of evidence. So even if the Commission had the power to, let's say, conduct market investigation in the digital sector, still the investigation will last for a long period of time. So this will not shorten basically the length of the investigation by the Commission. And last but not least, I think if we translate the NCT mechanism from the United Kingdom to the EU system, we would have also a problem of judicial review. So in United Kingdom, the CMA decision after the market investigation is subject to full judicial review by the Competition Appeal Tribunal. In Europe, a Commission decision after a sort of market investigation would be reviewed by the General Court, which adopts a lower standard of review. So it recognizes to the Commission a margin of discretion in relation to complex economic and technical assessment. So it limits its judicial review to manifest errors by the Commission. So first of all, we will have a lower judicial review at EU level in comparison to the UK. And also, I think we will have a problem of legal standing. So under Article 263 of the treaty, an individual or a legal person can always appeal, can ask the annulment of a Commission decision when the individual is the addressee of the decision. But in the case of the NCT, the Commission could also adopt a general measure applicable to all, let's say, the companies operating in the market. So in that case, under Article 263 of the treaty, we will not have an individual addressee. So we would apply the so-called Plowman test, whereby only claimants which are individual and individually concerned, negatively affected by EU Act, can challenge the validity of the EU Act at the Court of Justice. And I don't think this type of legal standing would be fulfilled to challenge the validity of the Commission decision at the end of the NCT proceedings, when the remedies full concerns all the companies basically in a specific digital market. So these are my concerns about the NCT, even sort of watered down version limited to digital markets.
Thanks, Marco. Jessica, a tough question to you. Would it be necessary to the authorities to monitor the gatekeepers?
Well, that's a very hard question to answer, but I believe it would be necessary to allocate a lot of personnel. So I'm not aware of the exact number of people in the DG Comp, but I guess it would be around 400. And if you need to monitor the gatekeepers or emerging gatekeepers, how much users they have, or if they are locked in, and what are the solutions in the market, this would be very time consuming. So I believe the best strategy that an authority could go is to implement a type of screening technology. So basically using technology to monitor technology. I know Kadi has a very interesting example, not related to the digital markets, but in 2013, they created this project called Projeto Cérebro, Project Brain, to screen companies and bid rigging cartels in Brazil. And so far, what I understand is that this has been successful. It cuts a lot of time of investigation of the authority. So a similar approach could be taken like this one to monitor the gatekeepers. Thank you, Vicente.
Thanks, Jessica. Well, we are arriving at the end of our panel. I'd like to thank so much my dear friend Marco, Giuseppe, and Jessica for sharing your experience, your knowledge, and your time with us. And considering that we are in the middle of December, I would like to wish you all, speakers and audience, a very Merry Christmas and a normal 2021. Thanks so much, and I hope to see you in person soon. Bye-bye.
Vicente. Bye, everyone.
Thank you.